voluntary. We are very familiar with the effects of alcohol, generally speaking. Courts have recognized that general members of the community have had sufficient experience with alcohol, either as users of alcohol or having witnessed those who have used alcohol, that we know alcohol is an impairing substance. Certainly, alcohol when drinking or consumed to excess is an impairing substance. But our statute makes it also a crime to be impaired as a result of the ingestion of drugs. And this is an area we'll talk about more in a few moments, but it has proliferated across the country, the targeting of DUI cases based on impairment derived from drug use, and that's prescription medication or illicit drugs, or even some over-the-counter drugs could cause somebody to be impaired. Our statute recognizes that somebody is impaired or could be impaired from the consumption of alcohol and the combination of an ingestion of drugs other than alcohol. So unlike some jurisdictions where the requirement may be to prove impairment to the slightest degree, in South Carolina, I think the standard is as high as it can be, and it's as high as it is anywhere. You've got to be able to show impairment, not consumption. Some of the campaigns that the government uses from time to time to get the word out about their targeting people who've consumed alcohol or used drugs and are driving sort of implies a very low standard, that if you drink and you drive, then you're going to jail. That's not the standard. And I think it's important when you're defending the case to understand exactly what the government must prove. It's not that somebody had something alcoholic to drink and then drove a car. In every jury trial I've ever participated in, and during the charging on the law, one of the things that is always charged to a jury is that it is not a crime to drink an alcoholic beverage and drive a car in South Carolina. The crime occurs only when someone has consumed a sufficient quantity of alcohol or a sufficient level of drugs that they now are no longer safe to drive their car. They're posing a danger on the roadway, and they should be removed for the safety and benefit of everybody else in the community. But ours is not one of just consumption and driving. And if you defend these cases, or even if you prosecute these cases, you watch video like I do, and you see instances where it's very clear based on what the officer has to say to the person at the roadside, or just generally how they handle the case, that their belief is all they've got to do is establish that the individual had something to drink before driving, and now they're driving the car. So I believe in first things first, and so I think in every case you need to refresh yourself on exactly what the standard is and what the law requires. Next slide. One more. Here's sort of where DUI, in my opinion, is in its own unique category of crimes. And while it, as I said, is serious and deserves to be zealously prosecuted, it's different. It is a crime that in many instances relies simply on the opinion of a law enforcement officer. And sometimes a law enforcement officer who has been designated as a DUI enforcement officer and works with a unit where the target is clearly to make arrests while on duty. DUI, in my experience, is the most incentive-laden charge that any officer could make. And so I think there is incentive for officers on the roadside to err on the side of caution and make an arrest. But it's important to realize that the underlying conduct itself is not illegal conduct, drinking and then driving a car. I don't want to beat this horse too much, but I do see a lot of cases where that is the apparent standard applied to the decision to make the arrest. Fortunately, that doesn't always play out with regard to prosecution. I think prosecutors, certainly prosecutors I've dealt with, take a very serious look at the underlying facts and conduct to determine whether this is a case based on impairment or based on alcohol consumption, or marijuana is another one that the officer can clearly distinguish when he walks up to a car, tell that there's the odor of marijuana in the air, and then immediately shift to a DUI investigation. But this is a crime where, in its base form, the underlying conduct is not illegal, and the accusation itself is based on the opinion of a police officer who is making judgments on someone based on their demeanor and conduct, someone he's never seen, never talked to, but it's based on opinion. And then culpability is, this is sort of you're assumed. If you have consumed alcohol, then you know it is an intoxicating substance, and therefore your knowledge of that fact locks you into the consequences. And while we use the word inference, based on, in part, propaganda campaigns to get out the message that if you drink and you drive, then you've committed a crime, we've created this belief, this myth, that if you have a blood alcohol concentration at a certain level, it used to be 0.15, and then magically it went to 0.10, and even more magically, it went to 0.08 without any underlying scientific proof to support any conclusion that somebody's impaired at any one of those numbers. But now there is this belief, and it's nationwide at least, that if somebody has a blood alcohol concentration of 0.08 or more, they are impaired. We all know that's not true. We know that that is an inference that can be drawn from evidence, but it is not a requirement. But if you're defending a DUI case, then one of the first battles you need to be prepared to fight is overcoming this myth that every juror who walks into the room is going to already believe. This is maybe the only kind of crime that everybody in the room already has an opinion about drinking and driving. And so those people with their opinions about drinking and driving believe that if you have a blood alcohol concentration of 0.08 or more, you're impaired. It is black and white law in South Carolina. Judges charge it to juries in every breath or blood test case where there's an alcohol concentration introduced into evidence. And that is telling a jury that you may infer that somebody who has a blood alcohol concentration of 0.08 or more is impaired. Defending these cases, you've got to be able to take that issue head on. You've got to be able to show every piece of evidence that contradicts, every piece of government evidence that contradicts the conclusion that somebody's impaired at a 0.08. You're not going to find a medical doctor that's going to say that. You're not going to find any scientific research that is going to draw that broad stroke line. It is just, the result, in my view, of activism, and it's taken hold. But this is that kind of case. Not only can juries be allowed, encouraged, instructed to draw inferences about impairment from that evidence of just a number, they're also allowed to draw conclusions based on what somebody did not do, that somebody did not take a breath test. They're allowed to infer consciousness of guilt from that fact. And no other kind of criminal case that I can think of is a jury ever told what they can do about what somebody being investigated for a crime and ultimately prosecuted for a crime did not do. And quite to the contrary, they can't even be told if somebody refused to answer questions or somebody refused to voluntarily give a DNA sample or any other evidence that might be used against them. So this is what you need to recognize going in, is that when you walk into the courtroom, you're already downhill having to fight uphill, because every person in the room thinks there's a magic line at .08, and if you're at it or above it, then you're impaired. If you're below it, you're not. And any of you who defended a case where the number was less than 8, then you know that clients walk into the room sort of with their shoulders back with a little strut, like they don't have any case on me. I'm just here to confer with you to get a little guidance on how to go about getting my case dismissed, because I blew less than a .08. And then you have to take them through the process of explaining to them what 08 means and does not mean, and where the line's drawn at a .05, that at that level and below, you're conclusively presumed not to be impaired from alcohol. But that, I tell everybody I talk to, by no means suggests that you're not going to be prosecuted. Because in every law enforcement officer that I can recall talking to, when the number is less than .08, they don't start looking for how to undo the process, how to unarrest the person. They don't even necessarily think that I can't prosecute this person. They then shift their focus to believing they must be impaired from something other than alcohol. And some will go the next step, that they're permitted under the implied consent law and ask for a urine sample. But some will just leave it at that and rely on their opinion, their training and experience as the basis of the opinion, and what they intend to rely on in trying to prove the impairment. So this is something that in prepping my clients for jury trials, this is a conversation I have with them about the baggage that jurors are going to bring into the room the very second they step across the threshold. Let's go to the next slide. I mentioned this a few moments ago. There are these active campaigns that I think are impactful. And some of that, living at the beach, I think is a great idea, because, you know, my family comes and goes during the time that people are coming and going to the beach, many of whom have been drinking, whether they're allowed to do so or not. But the campaigns influence the jury pool, and that's why you've got to be prepared to address these issues head on. This first campaign, drink, drive, go to jail. That's clearly sending the message that the gravamen of the offense is not impairment, but it's the consumption of alcohol and then driving a car. The next one says, drink or drive, you decide. Every restaurant I go to, generally, except for some downtown, have parking lots. And so this is telling you drink or drive. Now, that's what when I go out, I take advantage of Uber, but not everybody does, and nor should they, because the crime is it's not a decision between drinking or driving, it's being impaired or driving. And then I can't see over here, you drink and drive, you lose. Why just one drink impairs your driving? So jurors are hearing these campaigns, and as a citizen and member of the community, I understand the objective. As a defense lawyer defending somebody who was arrested because they had a drink and not because they're impaired, I recognize the fact that I've got to deal with that issue. And so I'm telling you that you need to go into these kinds of cases recognizing the position you start from. Let's go to the next slide. Now, there is some, belief that only bad people are going to ever find themselves in a set of handcuffs and ultimately a jail cell. DUI is a kind of crime that could happen to anybody who drinks socially, or anybody who is under the care of a physician being treated with certain drugs. It can happen to, my looking at the sort of general client base I've had over my career, I've represented people from every segment of society charged with driving under the influence. It is a social drinking issue for some people. Clearly, it is a problem drinking issue. But there are people that have never been in a set of handcuffs, and this is particularly obvious when it's a 60-something-year-old person who the allegation is based on their use of medication. So it happens to people in every walk of life, and I'm, generally speaking, law-abiding, productive members of society, school teachers, lawyers, doctors, athletes, social drinkers can easily end up here. I tell my clients that one of the benefits of trying cases to juries is that if jury members are social drinkers, then there's no way they could never have thought about what if. There but for the grace of God go I. I think that that helps with getting a fair outcome, is that the jury would be composed of people who clearly could be in the same situation themselves. But again, it could happen to anybody. Move on to the next slide, please. All right, here's your garden variety DUI case. Officers patrolling see someone driving erratically, changing lanes without using a turn signal, crossing the line back and forth. They make a traffic stop. The common scenario is they approach the vehicle, they detect an odor of alcohol that prompts the investigation. In agencies where there are designated DUI enforcement officers, the routine traffic officer or patrol officer who made the stop often will call that more experienced DUI detection officer, we'll call them, all based on the odor of alcohol. The next aspect of the case for analysis is what evidence of impairment is there. The officer is clearly going to talk about the odor. They're going to talk about how long it took for the driver to produce their license, registration, proof of insurance, the fact that they gave them an outdated insurance, proof of insurance card, which is probably the most common. Probably happens more times than it does not, that somebody, and some of you listening right now, probably in your car have multiple years of proof of insurance cards. And so that happens even in routine speeding stop cases. But these are the kinds of observations that officers are now considering in deciding whether to proceed with this DUI investigation. They will always ask a question in one form or another of whether or not the person has consumed alcohol. And most people who have will say they had two beers, a few, something along those lines. Some officers leave it at that. Others will probe further to find out how many is a few. When did you have your last drink? When did you have your first drink? They take these admissions into consideration, and then they decide to ask them to do field sobriety tests. And as we'll talk more in a few moments, field test performance is a critical aspect of the case for the defense. And fortunately in South Carolina, we have the benefit of all field testing being captured on video and audio, and that becomes very significant in a thorough defense of a DUI case, being able to assess the officer's performance during the administration of field tests. I don't really expect a layperson who has never done field testing and has not been told what the grading criteria is going to be, not given an opportunity to practice and make sure they understand the instructions. When they make minor mistakes that are not your, classic falling down drunk, can't stand up straight, hit the floor with their hat kind of scenario. But when it's these minor missteps here and there, I honestly don't put a great deal of significance into those missteps. And I don't think jurors do either, because I think that they always go through that analysis of whether they could do what the person was being asked to do. So I find it a lot more effective, and I've gotten feedback from juries on this point, that it's a lot more effective to focus on the officer's compliance with his or her training, because as we all know, if we've ever looked at field tests and prepared to cross-examine somebody, these are standardized exercises, and so they're a significant part of the case. Because if ever you ask the officer, what caused you to form the opinion to place my client under arrest, there's going to be a great and a heavy reliance on these field test exercises. And then great weight is given, I think, preliminarily. The thing that most prosecutors give weight to and make decisions about is breath test numbers, and that's understandable. But we'll talk more about some reasons why that high number could be more beneficial to the defense. And then the inference drawn from a refusal. So this is the common case we defend, and we're going to get in some nuts and bolts stuff about how I go about the process from the beginning of a case, when this case walks in my conference room and I sign it up, where we go from there. Let's move to the next slide. Now, as I mentioned earlier, we all know how alcohol affects people. We understand that while every client we talk to will say, I never intended to go get drunk and then go commit a crime, get arrested. The fact that they voluntarily consumed it with a knowledge of the effect of the alcohol consumption, the law views that as being so predictable that that's all that really needs to be established with regard to alcohol. As I stated earlier, lay people can give an opinion about impairment based on general assumptions about what we all know about the effect of alcohol on someone. Let's go to the next slide. Now, when we shift to the drug case, this is something entirely different. And there are, in the agencies in the greater Charleston community, several officers across those agencies who have undergone training as drug recognition experts. And so often they will be brought to the scene or to the breath test room to conduct drug recognition evaluation. And one of the questions that is a part of that protocol is, have you used drugs, and if so, what drugs have you used? And so that it sort of gives you the ability to cheat a little bit in forming your opinion about what somebody might be under the influence of. This is an area, in my view, that is clearly outside the purview of common knowledge. We don't know the effect of drugs on people. We don't know, given the combinations of drugs that some people take, what effects they have on them. This is an area where the expert opinion is critical. Now, I defended a case in a nearby jurisdiction where a young guy was on his way to work at a place that required very intelligent people. He was a very intelligent guy, but he was a little odd. He was a guy that when he was not working in a job that required great skill with regard to computer programming, he was playing video games. He was in his room, that's what he did. But again, a very bright guy. on his way to work in bumper to bumper traffic, he tapped the vehicle in front of him. And the two parties got out, looked at it, very minor damage. Well, there happened to be an officer from another agency 2 cars back. And so that officer comes up, and where initially they may have decided to part ways without involving law enforcement, this officer came up to see what was going on and decided to call the jurisdiction, an officer from the jurisdiction where this minor collision occurred. And so the officer arrived on scene, and he had recently graduated the drug recognition evaluation program and had been so titled as an expert in drug recognition. And so he gets there, he questions the two. Again, this very awkward guy sort of raised his suspicion. He tells him to go back and sit in his car. He comes back and he asks him whether he had had any drugs, asked him about alcohol, but never alleged that he had any other reason to believe he was under the influence of alcohol. But he asked about drug use. And the guy said, no, I've not done anything. And he said, you sure you have not smoked marijuana in this car? And he said, I'm positive. I've never smoked marijuana anywhere. And he said, well, I think you have. I smell the distinct odor of marijuana. And so he put him through the roadside investigation and arrested him for driving under the influence, took him back to the agency and completed the DRE protocol on him, and stated in front of a camera in a breath test room, sort of a odd pronouncement that in my expert opinion, you are under the influence of THC. And so this guy goes off to the local detention center. His dad called me. I'd represented the young man's sister before. And the dad said, look, my son just got arrested for DUI. Now this happened at like 7:30 in the morning. And he said, I'm going to be honest with you. If this had been my daughter, I wouldn't have given it a second thought. But this kid is not a partier. He doesn't drink. He doesn't hang out with anybody. He goes to work and he plays video games. He's very odd, but he's not, if he's using drugs, he's hoodwinked me. And so he said, I got a close friend who was a federal probation agent, and I called him because I'm like, either I've just been completely snowed. He was on his way to pick him up after his bond had been set. So he calls his buddy, the probation agent, and says, look, here's a story, what I need to do. And he told him the test to go have administered immediately, to include a hair follicle test. And we waited on the results. And so I went to a pretrial conference, talked with the then prosecutor who, where we're going on this case. And I said, well, the guy's, I'm convinced, not impaired. And so we talked to the officer, and he's like, no, that guy was definitely under the influence of THC. I don't have any doubt in my mind. And again, he'd gone so far as to stand in front of the camera and make his pronouncement about drug-based impairment, marijuana to be specific. And so we decided to sit tight on the case until we got those results back from the drug test that we had voluntarily done, and they came back completely clean. He had not, and the kid said he can't recall if he had ever even taken an Advil, but he'd certainly never used an illicit drug. So this, I can tell you, that officer was as convinced as any officer I've ever seen. He'd gone out through that program and was absolutely convinced that he could detect impairment. And granted, I met the kid, he was peculiar in some ways, but the fact is he was always that way. Maybe he was in a heightened state of anxiety, obviously, from dealing with the officer having the accident. But this is that, and that officer would have been as content to prosecute this case as far as it could go, absent absolute scientific proof to the contrary. So when we're dealing with drug cases, then you need to be prepared to go that route. I tell clients who come in with DUI drug allegations that there's no question that I'm going to require you to hire an expert so that we can look at the analysis of the substance and know whether it was impairing or not. I'm not going to tell you too many war stories, but I had another case where I was representing an elderly physician, and I guess elderly is relevant, but he was in his late 60s, and so a relative rather, but he was in his late 60s. He'd been out to dinner at Poe's on Sullivan's Island with another doctor, their two wives, and he had a hamburger and ordered a beer when they got there, drank that beer. Before he finished his burger, he ordered a second beer, and he finished his burger before he finished the second beer. So his account was he'd had a beer and a half. He gets stopped, and it's on video, for weaving out of his lane, and there was no dispute. He had crossed the line, the fog line, 3 times, and was stopped on the top of a bridge. It was very gusty on the top of that bridge. He answers the officer's questions about where he was coming from, alcohol consumption. So she has him out of the car to do field test. He does poorly on the field test. That's not my slide, but they were being hacked. But he does very poorly on the walk and turn and the one-leg balancing test. And so she arrests him. He goes in, he blows a .01 on the breath test machine. And he had been having a very lucid, intelligent conversation with the officer, just incredulous that he'd even been arrested. And so when the result is a .01, she confers with her supervisor, and he says, so what's the procedure now for me to be released? Can I call my wife to come pick me up? And she said, no, we're going to go to a local hospital, and we're going to ask you to provide a urine sample. And so he had his own blood sample collected at that time, and they awaited the urine results. The urine results came back, and the officer asked him, do you take any medication? And he said, I do. I take a prescription which he named. It was a blood pressure medication and a cholesterol medication. And those were the 2 medications. And ironically, he was a cardiologist. And so we await the production of his independent blood test and their urinalysis, and the test comes back, and the only thing in his bloodstream was exactly what he said, and that was the metabolites from the 2 drugs he mentioned. There was absolutely nothing impairing in his system. But it was clear from the conversation I had with the arresting officer that she based her opinion on his driving, his field test performance, and his admission to having taken drugs. And he gave her the name of it. But she was of the opinion that if you had drugs in your system and you couldn't do field test, then you were impaired. So I've seen other similar cases, but when we get into the arena of drugs and DUI, the same rules don't apply as apply in alcohol-based impairment. And as a defense lawyer, you need to spend some time preparing yourself with regard to training. You can go through the same drug recognition course. There's a short course, there's a longer course, but these are available through a couple of national organizations and national experts for you to go through the program and learn from the inside out. And one of them, the one that I've gone through, is taught by the guy who was head of a state police training agency on field testing for a number of years. And he is an expert with regard to the literature, the science, and the junk science in this arena. Let's go to the next slide. All right, so let's go on past this one. Past this one. let's load this. I guess it's past this one. Next one.
Okay, Drew, if I could stop for just a second, I'll go ahead and make the first poll live. So everybody, if you will take the opportunity to respond to that, I would appreciate it. And I will move to the next slide, Drew, once I get that off of the screen.
Gotcha.
Drew, feel free to go ahead. You don't need to wait on that.
All right. Well, I'm going to have a little water break.
Sure.
Okay, now with regard to preparing to defend the case, all that stuff's already happened. Your client was last night out on the roadside, got stopped for weaving, had an odor of alcohol about him, admitted to having a few beers, didn't do particularly well on field test. They were arrested and they refused a breath test. So now they come into your office, and here's where I think you begin. You've got to have a system for them to come hire you now. Believe it or not, if you Google DUI defense lawyer, you probably find just tons and tons of people who do DUI defense work. And fairly, it does fit in the summary court system at the first offense level, and it is initiated on a uniform traffic citation. So it does have the appearance of a traffic offense. It's far from that. Now, anybody who is willing to put in the time and effort and pay the price both in terms of what you dedicate to it and what you pay to go through these things I'm going to tell you about, everybody can be successful in defending a DUI case. But it's important, particularly for young practitioners, to know that it's not a traffic case. It's not a traffic case by any stretch of the imagination. The person that sits down in your interview room across from you could have custody of their children on the line. They could have their career on the line, their professional license on the line. They could have a lot more at stake than a fine. Nobody really wants to go give the government $992 in a DUI first offense refusal guilty plea, or a little more than that for a DUAC .08 guilty plea. But that fine is not the end of the world. And most DUI first offense cases, in my opinion, don't carry the aggravating conduct that would justify jail in the first offense case. And it's certainly not a common occurrence. Of course, you should, as do I, inform your clients that judges have the prerogative to penalize somebody as they see fit, and then I explain to them exactly where they fit within penalty options and penalty range. But as a defense lawyer, you sort of know the pulse beat. And in the state of South Carolina, honestly, the typical punishment meted out is that monetary fine. So paying that, while nobody really wants to do it, and it may take some people a little time to get it done, that's not life-changing conduct. But the things that flow automatically as collateral consequences are the kinds of things that are severely punitive. Having a lifetime criminal record, particularly somebody just starting out, or, for that matter, any other law-abiding citizen, the idea that I would never think to voluntarily do something or violate any rule that would result in a criminal arrest and risk of prosecution. There are people whose mindset is, I just can't see, I can't live with that. I can't see myself as a criminal. I'm not that person. I don't have that mindset. and you have to talk to them about just where they are with regard to how the law applies in DUI. But some people, that notion of a lifetime conviction on their record is problematic. So there are a whole lot of dominoes that can fall when somebody is arrested. So it's not a simple traffic ticket matter. So therefore, you don't wing it when somebody comes in and just, let me get a copy of the ticket. Here's what my fee is. Can you pay that? All right, here we go, sign this, and we're off to the races. This requires a lot more front-end effort. And so you need to have a system from the time that you talk to them on the phone, scheduling the interview. Now, I would say in a former life that I do all of my interviews in person, but that process changed a few months ago to where it's just not prudent necessarily to have people who've been hanging out in bars in particular sitting across the table from you. So now, and I've known lawyers who've successfully handled intakes and interviews by phone over the course of their career, and it works for them. But I just prefer the personal interaction, sizing them up and letting them size me up. So I'm going to talk to you in the next slide about the system that I use, the next couple of slides. You need to, and let's go back, not there yet. The part about knowing the rules, most people charged with DUI will have the criminal charge of driving under the influence pending in a summary court, second offense and above, clearly in the Court of General Sessions. But those that have refused breath test or blood test, blood requests are rare, limited to specific instances we'll talk about later. But those that have refused a breath test or refused a urinalysis, a sample for analysis, or who've taken the breath test and had a result that's reported to be 0.15 or greater, they've got a simultaneous legal problem running at the same time the DUI prosecution's running in the administrative law court, in the Office of Motor Vehicle Hearings. They have their own set of rules. And so you need to know those rules before that person walks into your office, because you're going to need to tell them cogently the interaction between those two legal problems and the differences in those two legal problems. One is a civil proceeding in an administrative court, and you need to know what options they've got with regard to licenses and what they must do and what deadlines they face in order to comply with the rules. You need to know something about the science of breath testing, blood testing, urinalysis, and I don't know whether we'll call it science or not, but field testing. You need to know where to start with the representation of them. You need to know the law. And that's both that statute. I put a copy of that statute in every file. It's there even though I could quote it. It's sort of a part of my system. So I trust the process. I put it there. And then you've got to know those key cases that are relevant to every garden variety DUI. You need to know State v. Graves if it's a one vehicle accident case or under the parameters set out with regard to an encounter with law enforcement where you're not physically driving the vehicle at the time. Everybody needs to know Mount Pleasant versus Roberts, State v. Osborne. There's a whole list. But you've got to know not just that statute, but you've got to know those cases that are critical to the elements of the offense in South Carolina. Let's go to the next slide. Next slide. No, there we go. There we go. Okay. Now, as David mentioned at the beginning, and many of you who know me know, I had the opportunity to work for the last 8.5 years of his life with one of the pioneers in the area of DUI defense. Reese Joy. Reese Joy was a force of nature, and it was not just here in Charleston or here in South Carolina, but it is indeed nationwide that he was recognized as a dean of DUI defense. There are a couple of major national organizations that some of you may be members of that focus on specifically training lawyers in every aspect of DUI defense law. The National College for DUI Defense, the DUI Defense Lawyers Association are the two I have in mind. Reese was the genesis of the National College for DUI Defense. It was his idea. He reached out to lawyers that he had learned to be focused. We can't say specialists, so we'll say focused on DUI defense, and brought them together in a hotel room at the maybe the Hilton or the Sheraton in Chicago at the airport, and they met and ultimately formed that institution, the National College for DUI Defense. But they also formulated a plan and made a presentation to the American Bar Association to put on a program as a part of ABA CLEs around the country, specifically geared to defending DUI cases. And each of those guys involved in that ended up publishing books in one form or another. But Reese was a very meticulous guy. He was an engineer by training, and so he was, you know, a systems guy. And the system I employ, not surprisingly, is derived from his system. I took some of the things I'd learned from him and modified them to suit my philosophy, and I took other things from him and I use them to this day. And the next two slides after this that we'll simply pass through, but that you can see from the link that David will put up later. And incidentally, anything that I mention that you'd like a copy of, all you need to do is email me, and I'll be happy to share anything I have with anybody who's interested in it. But the intake form asks for specific information. This means that, you know, some offices you've got one person who answers every phone call, maybe two people who answer every phone call. Some you've got more than that. But this is a form where when you're doing a DUI intake, everybody's asking the exact same question and getting the same information, so that when I review it, when you review it, those things that are critically important to the outset of the representation in a DUI case, you have at your fingertip. So there's a form that we use as a part of our computer-based client file system that is, you know, you talk to claims adjusters on the phone, you hear them typing in everything you're saying as you're talking, or insurance adjusters. And it's the same thing with my office. When somebody calls, these forms are being filled out as the conversation takes place. I don't use this routinely, and that is initially Reese just sat down in his interview room in front of a video camera and recorded an overview of the DUI law in South Carolina. And so when the client was waiting to meet with the lawyer for the actual interview, this information was being disseminated. Now, that's an effective way of covering information that it'd be so repetitive, and it would save time for you. You would not be sitting there for that 15 or so minutes. I think Reese's interview video, first one I saw, might have been 40 minutes long. I cut mine down to about 12 minutes. But again, I don't use that anymore. I prefer the direct interaction to the extent possible. I think that's where you figure out who you're dealing with and they figure out what you're about. I take a photo. I don't, but my intake assistant takes a photo of the client to put in the file, because as we all know, cases can take some time to reach an ultimate resolution. And so you may talk to your client today, and there not be a pretrial conference for 3 or 4 months. You talk to them then, and then things sort of creep along for another 3 or 4 months, and you might talk to them on the phone a few times in between. But there have definitely been instances where I needed to look at that photo when I'm telling my client to meet me at X, Y, and Z lobby of the courthouse. That photo can come in handy and avoid you walking in looking like you don't know who your client is. And this doesn't obviously just apply to DUI, but in representing anybody in a criminal defense case, but you need a written fee agreement that spells out exactly what you're representing them for, what they're paying you, in what way they're paying you, what you're not representing them in, and it needs to be as specific as possible in terms of when the fee is earned and what you'll do in terms of appeal or not, what you do in terms of file retention, and these things are set out in writing, and that protects you, that protects them. If you're going to charge them travel mileage or something, you have them initial that. There is a file opening instruction form that I use. So I'm in the interview room, I do the interview, I've got all the information I need, and now I'm directing the legal assistant, that I call a case manager, who's going to handle it based on what court it's in, what to do next. And so it might be, I'm going to hand carry a jury trial request because I'm going to go based on issues that I'm expecting to be fruitful for me. I'm going to go meet with the officer, and maybe we can avoid the need to put the case on the trial docket. So that instruction sheet to my assistant says whether to go ahead and request a jury trial, whether to prepare it and put it in the file for me to carry it. It talks about what records to obtain, what releases to get from the client, discovery. I have different versions of discovery based on the kind of case. A refusal discovery motion is different than a breath test result motion, different from a breath test refusal, different from a blood test or urine sample case. I then have an information letter, and this all goes in a folder that I'm sure many of you have, but a folder that I'm handing to them when they walk out of the office. They've got a file folder, so I'm going to keep papering that file for them throughout the representation. But this letter, I give them all this information about the administrative process, jury trial issues, deadlines, etc. And then there's this information letter in the folder that basically reiterates that information, because they're going to have retained some of it and some of it they're not. Then I've got a 28-page questionnaire, and it takes me from A to Z on who they are. And I tell them that I get basically a snapshot of who they are in the interview that lasts in the neighborhood of an hour, some a little longer, some a little less, but that's a snapshot. The questionnaire is going to be more of a portrait, because it's going to ask them a lot about themselves, because when representing somebody you don't know, information is power, particularly when you are trying to figure out why they did the way they did on a particular field test. So I ask them about medical health issues, injuries, surgeries. I cover the gamut from who they are, where they were born, when they were born, their driver's licenses they've held in their lifetime, education, employment, military service, community activism, religious involvement, everything I can think of to help me prepare to have an intelligent conversation with the prosecutor or an officer or both with regard to who I'm representing. And that is an invaluable tool. And when I sit down to prepare, work on a file, if that's not there, then I get with the case manager immediately, because that's not an option. That's something that I think is absolutely critical. And then, they bring their whole stack of paperwork in a DUI case. You've got the citation, you've got the notice of suspension, You got the notice of advisement of implied consent rights. You got bond information. You got the, the breath test report, a SLED collection report where they collected a sample. So I make copies so that their file that I'm giving them has exactly the same documents that my file that I'm opening and will continue to work has. I don't hide anything. The only time I've ever not given a client something is when a specific case, and it's never been a DUI, there's a reason. And I explain the reason and why I can't, but that I'll maintain it. And other than that, they get everything I get. And then I give them an instruction form, because when I receive the incident report and the videos, I want them to review those things and give me feedback with regard to what they recall. And they've already told me their version of the event. They gave a snippet of that during the initial intake with my case manager. And then during the body of that interview, they're giving me A to Z on that. In that questionnaire, I'm asking them again, tell me when you woke up and what happened from then until you got bonded out of jail. And so then when I get the police report, I'm adding that feedback, and it's telling them, give me your comments in writing. Because, sometimes they'll tell you, no, I never did the one-leg stand. That's highly unlikely, but okay. And you then get the video, and now you say, look, you told me this 5 times that you didn't do a one-leg stand. Here's you doing a one-leg stand. Or in another one that is always amusing when it pops up is, they gave me the breath test in the patrol car. I said, no, we don't do that in South Carolina, which says to me either you've been arrested before in some other state, or you just don't know what happened. And of course, that's never the case. But it's all about getting as much information, in my opinion, as you can. Not for the I gotcha or the I'm gonna cover myself scenario, but so that you can start figuring out what I'm gonna do with all this. Is I'm working toward a strategy on how best to represent this person. So this is critically important stuff. Let's go to the next slide. This is the computer-based intake in our case management. And this is the form when they walk in the door of my office. This is handed to them on a clipboard as the case manager takes their little stack of papers to go back and make copies of everything. This is something that's handed to them, and we're again asking them about specific aspects of the case, information about them. And this is important stuff, to include their weight. Because there are 2 factors that apply to a proper analysis of field test performance, and particularly with regard to the one-leg stand. According to NHTSA's on training and research and training materials, somebody over the age of 65 or 65 or older is not a suitable candidate for that test. And in previous manuals, the walk and turn had the same disclaimer, as is the case with somebody who's more than 50 pounds overweight. So in my trial notebook, I've got this body mass index chart that addresses ideal height and weight, and that can become a factor in the analysis of field test performance and certainly cross-examination. So this is not just asking for stuff for the sake of asking for it. And then as many ways as you can contact them as humanly possible, because it gets very frustrating when you're having a time contacting somebody. Next slide. All right, and in my system, and I've had a couple of assistants that I've had to go back and emphasize the significance of this. And this is, again, something that I got from Reese, and that is every file looks exactly the same. That photograph is in the exact same spot in every file. The charging documents, be that a warrant, a uniform traffic ticket, an e-ticket, whatever it is, it's in the exact same spot in every file. The information relative to the implied consent part of the case is in that. It's got its own section of the file. Relevant statutory case law, its own place in the file. The legal agreement, the representation agreement, any payment records has its own place in the file. That green questionnaire, I didn't tell you it was green, but that questionnaire is all on green paper. There's another color-coded aspect of this too. But that green questionnaire, I know exactly where to go when I need something in that file. And so everything has its place. I've got a redundant calendar system where I'm using 2 calendar systems, but the needle-based calendar program is what I did for a long time, exclusively. But you know, with computer glitches here and there, I got a different one that I use, so I'm doubling up on calendar stuff. But everything from the moment we receive notice, be that by email, by fax, by U.S. Postal Service mail, we put those down. You document and meet deadlines with regard to the implied consent request, jury trial request, prelim request, and so on. The breath test report has generally information for you to access the video from the breath test room on the SLED website or SLED server. And I know from talking to the director of the implied consent section, Debbie Banks, that when officers are taught and officer certification to run breath tests are renewed, they're encouraged, but not required, to opt to print that data on the SLED report. You may have seen some that it's blank, and that's because the officer opted for whatever reason not to print it. That means now there's a little bit more effort that's going to be involved in getting that video and some time lag in getting that video. But in case you didn't know, you can immediately do video from the breath test. I know some officers are to the show, I guess they're already on the case, and here we go. And they do it that way. I don't do it that way, but that a step in the file opening process in my office is for whoever's going to be managing that file to download that video immediately, put it on disk, put the disk in the file. Now, under the implied consent rules, the Office of Motor Vehicle hearing rules, rather, you do not, Rule 5 does not apply. So there's no discovery motion that's relevant to the implied consent hearing. The rules provide for use of subpoenas to get information to include or whatever information you think relevant, you need in a case. So you serve the subpoena to get the roadside video. On the discovery motion, you get to the implied consent. In any of these cases, you know it is unilaterally set by somebody who has had no interaction with the defense or the state in the case. They just pick the next slot available and plug you in, and that may or may not work. So if you're waiting on Rule 5 production, odds are you're not going to have a response by that implied consent hearing date. And you go there and you say, I want to make a motion to continue this hearing to permit additional time for the roadside video. They are going to look at their rules, and Rule 5 doesn't matter. They're going to look to see whether you subpoenaed the information and whether you filed proof of service of the subpoena with the Office of Motor Vehicle Hearings. And if you did, odds are they're going to continue it and give the officer specific instructions on how much time they've got to produce it, or the likelihood that will be excluded, resulting in the recension of a suspension. So serving that subpoena is one of the preliminary tasks in opening the file. Now, I've seen recently, and I guess it's time that I address it with a couple of different local summary level clerk of courts. But on 2 occasions now, people that work for me have gotten feedback suggesting that my office is trying to circumvent Rule 5 by using a subpoena. And I know that arguments like that come up from time to time in general sessions cases, but the distinction here is, as I've said, Rule 5 doesn't apply with the Office of Motor Vehicle Hearings. The mechanism you have pursuant to the rules is a subpoena. So I issue the subpoena asking for the information that's relevant to the implied consent hearing. And here are the issues. The issues are whether there was a lawful arrest. We suggest that the state's got to establish probable cause, or at least articulable suspicion, for a traffic stop, and probable cause that the person was materially and appreciably impaired, was arrested for DUI, was taken to a certified breath test site, and was advised of their implied consent rights, both verbally and in writing, and that their mouth was checked to see if they had any foreign object in it that might retain ethanol alcohol molecules, and they were observed for a minimum 20 minutes before being asked to provide a sample, or that they were advised of their implied consent rights and then refused. So those are the issues that I've got to be prepared to address. So I need to subpoena the items that are going to be relevant to the litigation of that issue. So this is not a circumvention. This is malpractice if you're not doing it this way, because you're not going to be able to survive if you're relying on Rule 5. And if you've had this issue come up, and I have been able to show in every instance our compliance with subpoena service and proper filing of proof, and prevailed. But I've heard people arguing the discovery angle, and that's not complicit with the rules of the Office of Motor Vehicle Hearings. And then, of course, you file your discovery motion. I don't have a blanket discovery motion, as I mentioned earlier. I've got one that fits the kind of case. I try to be as specific as possible. The motion that I've used, that I've developed over the years with experts and attorneys with significant experience in blood case litigation, requires a whole lot more information relative to the collection and analysis of the blood sample and the operation of the lab. But I review the discovery motion, and it's filed, and we move forward. Next slide. Next slide. Okay, dissecting the state's evidence. So now you've used your discovery motion, you've used your subpoena, you have the material that you can get from SLED, you've downloaded the video, you've gone to SLED's implied consent site, you've gotten the breath test records, you're starting to compile everything that you need to thoroughly dissect the state's case. And South Carolina, as you probably know, is the only state in the country that has a mandatory video recording law in all DUI investigations. There are many other jurisdictions that have similar laws, but they're more on the ordinance level of subdivisions of the state, and not just overall. I get asked all the time by DUI defense lawyers around the country for a copy of our video recording law, 565-2953, and background on that video recording law. It was a long time in the making. It was signed into law in 1998. It has been modified a couple of times over the years. In my view, it is one of the most effective tools in law enforcement. And it is one of the greatest protections for a citizen. And every few years, at least, there's legislation introduced to try and gut this law of its muscle, and none have succeeded. And I frankly think we're going in the other direction. We're going to see video required in cases beyond DUI with some substance to them, not like our current body camera legislation, which requires a recording but doesn't really mete out any consequence for failure to comply beyond perhaps local agency policy. But 2953 mandates the car the officers operating have a video recording system in it that is video and audio. The officers wear a microphone, and the law says that that video recording must begin no later than activation of the blue lights. Often that means that you will not see the alleged traffic violation, though some agencies are now using camera systems that are passively recording, and then once they activate the video and the lights come on, the camera comes on, then it's preserving and giving you a minute or two of driving prior to the actual physical activation of the camera by video light activation, or blue light activation rather. So the recording must begin no later than the activation of the lights. It must include essentially the conduct that the officer relied upon in forming his opinion that your client was impaired. That means field test, specifically the arrest itself, and then Miranda. Now, some of the most probing conduct that is captured on video is the things that happen before and after field test. And so the time that the interaction between your client and the officer, when the officer walks up to the window of the car, this, as I mentioned earlier, their reliance on how long it took to get the documents, where they gave them the wrong outdated insurance card, when those things aren't present, then that's information that you need to point out, because I think where the officer and the state is going to point to every single thing the client did wrong or hesitated on or what have you, it's incumbent upon the defense to do a similar analysis of everything your client did right, and that you can show counter the opinion that they were impaired. So that conduct, that interaction, the conversation that takes place, sometimes an officer, and I've seen this in a case that I tried, the officer says there was a conversation that did not occur. The audio is clearly working, and you listen and you listen, and you can't find that statement that the officer wrote occurred. And sometimes I think that that is the result of cut and pasted incident reports, not necessarily maliciousness and deceptiveness, but nevertheless, it's there, and it's an issue that you need to identify. It's critically important to have these field tests on video, because if your client makes 5 mistakes in the performance of field tests that they've never practiced and don't really understand, never been asked to do before, and the officer makes 12 mistakes in the administration of the test, then you need to be prepared to point that out. And then, you know, Miranda has become sort of a bright line issue in South Carolina. It used to be required that you had to read it twice. And it shifted around a little bit. The intent when this legislation was being processed, so to speak, was that motorists be told that they're not required to participate in field tests. But the compromise was that they be read Miranda. There have been a number of instances since the folks on the government side of the ledger wanted to try and get rid of it, but that was a compromise that it was, whether they know it or not, arrived at to satisfy the government side. We wanted a very clear statement to drivers that you're being investigated for driving under the influence. We're going to ask you to do field tests. You don't have to do them. So the compromise of Miranda, but the Supreme Court has made very clear that that is a mandate. It must be there. These things, this is where that, where your knowledge of the case law underlying the video law itself become critically important, because the Supreme Court has taken a very clear stand on what is required with regard to these video. And then the breath test site, video must include the entire test procedure, person taking or refusing the test, the actions of the test operator, and up to the point, the only time that this video can be ended before the actual end of the entire testing procedure is when somebody has clearly been informed of their rights under the implied consent law, verbally and in writing, and they articulate their refusal clearly. Then the video recording can end at that point. But there's a lot to be learned for defending a case from these two video recordings. And as I mentioned, the law is very strict with regard to the need to strictly comply with these requirements. Now we have additional video in every single case except with all the cases with the Highway Patrol. So every other agency in this area, the officers are wearing body camera. And that video can be very helpful to the defense, because sometimes I've seen them toggle their lapel mic off to where the video camera from the car is still running, but the audio is no longer recording, and they're having a powwow talking about something about the case. And I've heard wonderful things like, I don't think he's 1055, and I'm gonna go ahead and put him through the test because I need to practice. That is a 10 code for DUI. So the downside of all this body camera video is that you need to look at it all. And a case that you might have had an hour's worth of video, you can now have 4 hours worth of video or more. If it's a felony DUI scenario, I've had one with 14 and a half hours of video that you have to look at. But video is important. And in analyzing the case and preparing to defend it, my approach is to view the video the first time strictly to determine whether I believe it complies with the requirements of 2953. If I believe it does, then I move on and I review it a second time to look at the way the officer administered the field test to measure them against what NHTSA requires with regard to the administration and interpretation of the field test. And then I come back and look at everything my client did that was good and favorable for them. And then I look at everything they did that was not favorable for them and go from there with regard to what might help me explain that. What from my green questionnaire with regard to their medical condition or treatment might help me probe further for other records on their part that shows some issue that might help illuminate that. But the video is incredibly valuable. Let's go to the next slide.
Sorry, Drew. I'm going to go ahead and make the second poll for today live. If everybody will go ahead and complete that, and then I will switch us to the next slide. Sorry, Drew.
It's all right.
Drew, feel free to continue when you're ready.
All right, you move this, or I'll get to, there we go, all right. Okay, so you've examined the video and you know from a factual perspective with regard to the things that are stated in the incident report, the things that are clear from the video, and don't ever assume that they're gonna match up. There are sometimes major discrepancies between what's on video and what's in that report. Sometimes there are several minor discrepancies between what's there and what's not. But once you've started sort of framing your case with regard to that part of it, now you've got to deal with what, based on the myth about 0.08, juries could give a great deal of weight no matter what, and that is results of breath, blood, or urine test. Now, I'll start with the easiest one, and that's urine. SLED doesn't really like urine cases based on my conversations with relevant parties. Typically, they're producing a test showing just a metabolite that was there. It is not an ideal substance for toxicological testing. There was a movement in South Carolina several years ago where a former chair of the Senate Judiciary Committee had been approached by one of his constituents who moved in from out of state, but he was in a saliva testing business, and he wanted to try and gain a foothold here in South Carolina, where that, in addition to urine, saliva was being used to test for blood alcohol concentration and so on. I testified in a subcommittee hearing on that issue on behalf of the South Carolina Criminal Defense Lawyers Association, and it may be the only time that I can recall that both SLED, the Attorney General's office, and the Criminal Defense Bar were in lockstep with regard to keeping that out of South Carolina. And it was during the conversations on that subject matter that I learned they really don't like urine either, but they love blood. So urine is something that generally you stand a good chance of being successful in overcoming any urine result, depending upon what information they give. But often it's a presumptive test, and so that's simply telling you there's a metabolite and giving you nothing else. What it is showing is that your body's already metabolized and discarded it, and here's the proof. Is not showing what needs to be shown to show impairment, and that is what's affecting the brain, the central nervous system. The most effective evidence for that is blood analysis. But you get your breath test report, and instead of it being a refusal, if it's a refusal, you start exploring reasons why your client would have refused the test. There was a circuit solicitor arrested in Charleston, not from Charleston, but from another part of the state several years ago, and it made national news when in the breath test room on video, he said he didn't trust the data master machine. So that would be an effective tool for his lawyer to use in defending him to show why he took the breath test, and delve into what knowledge he had, because again, he was a prosecutor, so presumably he had some knowledge about that kind of evidence. But breath evidence, well, you deal with your refusal, and it's a different strategy analysis with refusal. I used to think when I first started practicing with Reese, I started there in 1999, that refusals could be high hurdles to clear. But there's been so much with our, endless news cycle that anytime a celebrity or an athlete gets arrested for DUI, there are, there are conversations at least where people get on and talk about the lack of trustworthiness of this kind of evidence. And so it's out there. And so there are people that in jury pools that could realize there's reasons other than consciousness of guilt that somebody refused to give a breath sample, particularly somebody who's done well on field tests and now thinks this is a never-ending process of gotcha. Until I do something, you're just going to keep after me. And so that is effective when that's a factual reality in your case. The most common evidence in a DUI case to establish blood alcohol concentration level is a breath test. And in South Carolina, all that is required is a testing of one breath sample. If you look at the scientific method, if the scientific method were properly applied to breath testing, this would be deficient, our methodology. Many states require a confirmatory test within 2 minutes of the initial test, And they also require a minimum level of agreement between the two samples. Your body metabolizes alcohol constantly, but not quickly enough that you could have a significant deviation in the results. So one of the inherent defense issues, in my opinion, in our breath testing model is that it's just not based in the scientific method. And then these are areas where, as a defense lawyer, you need to attend seminars where breath test experts are giving lectures. You need to go through training programs with experts in breath testing, and they're available. I am presently President Emeritus of the DUI Defense Lawyers Association, and this organization is comprised of the top DUI defense lawyers across the US and Canada and the top experts. I, as David mentioned, put together the Reese Joy DUI CLE every year. It's named Reese as the South Carolina Association of Criminal Defense Lawyers, but after his passing in 2008, we named it in his honor. And I put that together, and I routinely bring in these kinds of experts to be a part of the program so that the South Carolina Defense Bar can be exposed to this information and have contacts to reach out to help them prepare for a breath test case. The best kind of breath test case for defense is where somebody looks fantastic on a roadside video, very composed and calm on video in a breath test room, and blows a 24. You just can't hide impairment at that level. There are ways to make it clear that there's a lack of any ability to bring tolerance or anything like that. It just doesn't work like that. So there are experts that can help you prepare, and there are resources that can help you to prepare to deal with a necessary attack on breath testing. There are assumptions made by the computer software in the DataMaster DMT that we use based on the average person. And that seems like an impossible standard. Last I checked, I think the average person was a male under the age of 23, a Japanese male under the age of 23, but the article predicted that in the very near future, that would shift to an Indian person. And it's just, it's kind of absurd as far as I'm concerned to believe that you can apply even across gender the same standard. Temperature is an important component to proper breath analysis, and temperature can be different at different times of the day, and for different reasons, health-wise, between men and women. So there are a host of issues that you need to be educated on and prepared to address with regard to breath test. Never accept the number at its site. Now, again, video is the kind of thing that if it's showing somebody who's impaired, then, you attack every issue in those cases that you end up where you're having to try it because your client has no other alternative. And there are those cases. The gold standard of toxicology evidence, generally speaking, is a blood test result. But by no means should you assume that if you have a blood test number, that number is exactly what it says it is. There is room for contamination from the point of prepping the site on the body for collection of the blood. The collection kit that it was collected into is required to have anticoagulant and preservative in it at a certain specific level. The amount requires a specific amount of blood to be drawn into the test tube. And then there's a protocol that requires that they be inverted a specific number of times so that there's a proper incorporation of the anticoagulant and preservative into the blood. The test collection kit itself has an expiration date on it. That expiration date goes to the reliability of the seal and to the potency of the two substances in it. So an out-of-date kit could raise an issue, a question about the likelihood of post-collection fermentation that resulted in result that's inaccurately high. Then there are issues with regard to chain of custody, storage issues, exposure to temperature, access with regard to chain of custody generally. And then once it gets to SLED's lab, there's a whole long list of things that need to be examined to have confidence that this number is correct or this number is not correct. Because juries, judges give great weight to stuff that is presented in the context of scientific evidence. So there are courses you can take, but the bottom line is once you learn from a reputable expert or two, the issues and the information you need, you then shift to them to give you guidance on what's good or not. And the experts that I've used, and I wouldn't use any other kind, are the kind of experts that are credible and back it up. Their training, their work experience, their history of testifying in cases. And I've had experts to tell me, here's an issue, this shows contamination on this chromatogram, and it's not accounted for here. And I've had experts to tell me, I've reviewed everything and I think the result is correct. So you got it in a blood case. You cannot effectively represent your client if you do not learn all of that, because a jury, as I said, is going to give weight to it. And if it's a high number, a judge is going to give weight to it at sentencing. And so you need to be prepared to attack the chemical test, because that's invaluable evidence. Next slide. All right, soft evidence. I've talked a good bit about this, but in evaluating field sobriety exercises, you need to begin with the environment, the area where your client took the test, the conditions that they were in physically outside of having consumed alcohol. How long have they been up? When do they get up? What do they do all day? Did they just run an Ironman yesterday? You need to know these things that might affect their ability to perform. Officers should ask. It's not in the student manual, but in the instructor manual of the NHTSA standardized field sobriety test manuals. It requires that officers qualify the individual as a good candidate for proper or successful performance of the test. And the way that they would do that is ask them whether they have any limitation, physical limitation, any disability, any injury that might affect their ability to do the exercises, their ability to balance and walk in a straight line. They have their driver's license. I've never seen one ever take into consideration the weight. I've never had anyone take into consideration, David, your email is up. The person's age, but according to NHTSA, those are relevant factors in what an officer should assume at the beginning on whether somebody can do the test effectively or not. So the environmental factors would be traffic flow, weather conditions, number of people standing around watching them do the test, whether you're on top of the bridge and it's extremely windy and you've had a beer and a half and a burger and you aren't doing well on test. Those environmental factors are very important in preparing to cross-examine, and even to negotiating with the prosecutor. Being able to point out these things, sometimes you'll have multiple, especially early in the evening when it's kind of slow on the shift and nothing's going on. Somebody makes a stop, 10:55 comes across the radio, and several officers converge on the scene, activate with blue lights flashing. Good officers, DUI, task force type officers will know to at least turn off the forward flashing lights, but not all do. Sometimes they are in an environment where they're facing glass windowed building with flashing lights everywhere. And according to NHTSA, that's a concern. That's a consideration. The officer can misinterpret what he or she is seeing. You know, I've seen one case where the body camera, because the officer was so tall, was right in perfect position to catch the horizontal gaze and nystagmus test. I'm of the opinion, since officers are trained that ethanol alcohol causes nystagmus, that they're always going to say they see it because they are supposed to see it. There are over 104 recognized causes of nystagmus, and one of those that is naturally occurring in a large segment of the population. But looking, you know, an effective defense has to look at each of these aspects of the case and figure out how to tell the story to the jury. And the environmental factors matter a great deal. The person had been seated for a long time. That could be a factor if they've just finished a work shift where they've been on their feet all day. They're a bartender. There's a clear odor of alcohol, but they've been, you know, just worked a double shift. That's a factor, and you need to know that. And again, just because this label is attached to these drug recognition officers, the training is offensive. If you confer with a pharmacologist or a toxicologist who would never claim that they, with all their training and their degrees and their professional liability licenses, would say, I can tell you by looking at somebody's pupil size, I can take their pulse rate and you know, have them do an HGN and a walk and turn exercise, and I can tell you as an expert what drug they're under the influence of, then you know, they're a great counter to a DRE expert, and showing just how little training they've had and how absurd it is to believe that you should rely on their opinion about impairment. Now, I have gone as long, I think, as I expected. I can go, the next slides, I believe, are all about just penalty chart and that sort of thing. Now, this is where I just wanted you to know one thing, and then you know what the penalties are. But I can't emphasize enough that if you are going to defend people charged with DUI, with all the collateral consequences that they are subjected to, that you may or may not recognize at face value, then you need to think about going through the breath test training programs that are available, the field test certification programs that are available, training on blood, and attending CLEs. And right now they're all being done online, but attending CLEs where you're getting knowledgeable, qualified presenters giving you guidance. It's there. You can go do it, and it's easier now than ever before because the DUI DLA organization, we just moved to go virtual with our fall seminar that would have been in early September in Austin, Texas. So we're still having it. It's actually going to be a streaming event, but we're still having it. It's just now I don't have to fly to Austin, Texas, and it's a lot more convenient. Now, when you start getting into high BACs and greater than first offense level, your clients are really looking at serious consequences in the courtroom, in addition to the collateral consequences that they face. So my suggestion is to avail yourself of the tools and resources that are out there so that you can effectively defend it, and don't make your decision and advise your client based solely on breath test or blood test numbers. Look at the overall case and do it in a systematic and thorough way, and I think you'll be effective in defending these cases. And with that, I'm done.
Well, Drew, thank you very much, and I appreciate you making do with my uneducated assistance in trying to get the slides and whatnot up. But does anybody have any questions of Drew at this point? You could probably either the Q&A or the chat function. We can try and do that. Otherwise, I want to thank everybody for attending this function. We're going to continue to try and have our Lunch and Learn seminars every other Thursday from noon to 2. There will be other CLE events. I know there's a family law event that is scheduled that is a longer event. I can't remember how much long, at what time it is in August, but I think it maybe is next week. So be on the lookout for that. And if there's anything the Charleston County Bar, yeah, it's on August 27th. Thank you, Mary Lee. Anything else that the Charleston County Bar Association can do to try and help in these awkward times, please let us know. We've got a couple questions, so let me, no, actually some folks thanking Drew for a wonderful presentation. If you will send your bar number, your first name and last name in the chat, we can get you taken care of on that front. Drew, thank you very much. We really appreciate it, and I hope everybody has a great day.